Very good evening to everybody present here. So today we have uh, EDRICH sir. So he is going to present a topic on insurance, which is very important, and people lack lot of awareness in this. Even we people like in police department, other government officials, judicial persons gives lot of awareness regarding it. Still, it is a place where people are unaware due to cyber-based crimes and other online portals and internet usages in recent times, which has made a vast life losses like suicides and more during this COVID pandemic. So, to make an awareness and to know about the legal aspect, we have an experienced person who is none other than person Edrich Miranda sir. So we have already made a program on sir with sir and collaboration with it. So I don't want to give a lengthy program or a lengthy introduction on him. I feel so. So I will directly give the platform to the Edrich Miranda sir so that we can get into the program and we will learn and get to know about lot of knowledge and lot of awareness and how the Mumbai based as well as in Tamil Nadu how it is going in Drapo. So most welcome sir, and the platform for you is given. Yeah sir.
Good evening, everyone,
Good evening, sir. Good evening, sir.
and thank you, madam, for the introduction and the opportunity to share knowledge. So, I'll start with insurance. It's a very lengthy subject. Nevertheless, we'll divide it into life insurance and general insurance. Life insurance schemes are such as if a person dies, he's insured. If he dies, his heirs get a sort of compensation. There are various types of schemes. Under life insurance, it is, for example, you can get if you can get a compensation, or you can get just your money back, what you're invested in the policy, or you could get something like a uh, incentive, interest with along with that, and there are various types of schemes. Besides that, there is something for accident, and there is something for medical, and there is something to cover uh, different kinds of exigencies in insurance. Then you have the non-life sector. That is a very large sector. The non-life sector is covers everything from accident, motor vehicle accident, to aircraft accident, to space accidents, to shipping, to cargo of the ship, to hull of the ship, to the staff of to the sailors of the ship, and to every sort of thing, from farming to fruits, to agriculture, to just anything under the sun. You have different kinds of insurance schemes. Schemes for loss due to robbery, due to theft, due to fire, due to damage by rain, water, flood water, or whatever. So various types of insurances are there. That comes under non-life. It all becomes within the nomenclature of non-life. Now, insurance, basically there are uh, 6 principles of insurance. In this insurance business, you have 6 rigid principles and very noble principles. But of the 6, 3 are usually used day to day in your day to day working. They, the 3 that are used are insurable interest. One. Second thing is the doctrine of utmost good faith. Third is proximate cause. Now I'll explain to you what exactly this means by insurable interest. Insurable interest is something like, is actually what insurance is, something that compensates you. You don't have to earn money on insurance. You're not permitted to gamble and to rake in funds by taking insurance. You're supposed to just get adequate compensation for losses incurred and nothing more. Of course, you can get less, but not more. So that is the scheme. Therefore, insurable interest, if I'm an employee with ABC company, and that company, and I'm an important employee, and that company has some stake in me, that company can insure me. Otherwise, my parents can insure me, my spouse can insure me, or my children can insure me, because they are connected directly, if not directly, vicariously connected to an extent where they have some right and interest in me. Tomorrow something should happen, and if I should lose my limbs or be unable to uh, bring bread to the family, bring in earning, so they will be affected. My parents, my children, my spouse, and other people connected with me directly or vicariously. For example, a bank might get affected if I have taken a loan and I will not be in a position to earn. Then therefore, I will not be in a position to pay. So the bank can insure me to an extent, or my employer can insure me because I may have taken advance, or I may be a very useful employee there. They have engaged me with a hope that I will fill my full tenure and perform all my duties. And suppose if I should expire earlier, or I should become in a vegetative state and not in a position to carry out my functions and duties. So they are at a loss. Therefore, it, they can insure. But you should have some interest in the person who's being insured. Else, no insurance company will accept insurance. So, having said that, now let me give you an example. Actually, insurance interest is a type of investment that protects anything subject to a financial or other loss or other hardship. For let us take for example a flat. I purchase a flat which costs 20 lakh rupees. The actual price consideration of the flat costs 20 lakh rupees. But I invest only 5 lakh rupees upfront, my initial payment.
Okay.
15 lakh I have borrowed from the bank. So the bank has some vicarious interest in my life or debt or whatever, my inability to pay the EMIs or whatever. So the bank can insure that flat to the extent of 15 lakh only and not more, even though the flat was purchased for 20 lakh as per the agreement. As per the price consideration in the agreement, it is 20 lakh. But 5 has been paid already by me. So 15 has been borrowed. To the extent of 15 lakh or less, they can insure that flat. And they will be entitled to recover in the event, in an unlikely event of my premature expiry or whatever. So you cannot make money in insurance. You can only recover your losses.
Recover loss.
Therefore, they say financial, you have to have insurable interest. Now, let us come to the doctrine of utmost good faith. Utmost good faith means both the parties to the transaction, to the insurance agreement, are required to disclose of their own accord all true facts related with the particular insurance policy. You are not supposed to conceal anything. In a contracts act, sometimes one party is not legally obligated, maybe morally, but not legally obligated to disclose all facts, or may have erroneously not disclosed all facts. But here it is different. An insurance policy in insurance law, it is incumbent of both parties to disclose all facts at the inception. If a particular fact has not come to the knowledge of the opposite party, insured or insurer, You may be knowing the person who is getting insured is and the company is known as insurer, and the person who getting both are disclose all true facts. For example, if I take a policy of life insurance, let us say for this example, I give you life insurance, and I do not disclose to you in the policy that I have suffered from heart attack earlier. I had 2 attacks, and I am a smoker. I also imbibe alcohol regularly, and all these negative points I do not disclose, even though I know it. When I expire, and if you try to encash the policy or try to utilize the policy to get your compensation, it will be declined, repudiated. Why? Because even though I may have died for a genuine cause of heart, but they will not honor the policy because of the falsity that I have filled in the form at the time of submission, at the time of taking up the policy. Because I knew these facts and I had not disclosed these facts. Therefore, such a policy, such a agreement will get repudiated automatically. And that is the doctrine of utmost good faith. The doctrine of utmost good faith, I'll give you an example, that the insurer and insured both must be transparent and disclose all the essential information required before signing up of an insurance policy. Now we come to the third important rule of proximate cause. A proximate cause in insurance would mean is proximate cause is an event sufficiently related to an injury that the court deems the event to be the cause of such injury or damage. Let's take an example of if I'm driving a vehicle. I'm driving a vehicle, say ABC is the name of the vehicle, and I hit another vehicle, DEF. DEF is the next vehicle that I hit due to my error. The other vehicle goes and hits some people along Mr. XYZ on the footpath or on the road. So those people who are XYZ are entitled to recover money from me, because the court will analyze and find out as to what was the proximate cause of the accident. No doubt the accident has been caused and they have been injured by DEF, by vehicle number DEF. Nevertheless, the vehicle number DEF was caused to was forced to create that accident due to default on my part. I was instrumental in getting ABC was instrumental in initially causing the accident, and subsequently losses were due to me. Therefore, those parties who are not directly connected, they have received injuries from to and can break what the accident and they would not have got injured. So proximate cause you will get to understand as you come in the profession. At the time of argument in the courts, you will learn exactly what proximate cause is. Now let us shift on to further in the webinar. When an accident takes place between two vehicles or between a person, between vehicle and a person or whatever. Two types of cases are registered. One is for one type is one is a criminal case and one is a case for compensation.
Criminal compensation.
Simultaneously, two cases crop up. One will be registered by the police
Police.
under section 279 of the IPC. That's a criminal case, and then the state will be prosecuting you for rough and negligent driving or whatever. Then there is another case 164 and 166 that is for compensation. That will be filed before the Motor Accident Claim Tribunal. There are various tribunals in various states, and within the state also they have a main tribunal in the city, and then some matters come up before a district court where there is no tribunal. So the criminal case will go on between the respective state and the accused. Of course, you're the accused in the FIR. Therefore, that is a separate issue in itself. Then we'll come to the civil aspect of it. 166 and 164 and 166 for compensation. It Now, who gets compensation and how much does one get? First thing is you have to be insured. There is something known as no party fault. There are some very rare things which a lot of people are not aware of. Irrespective of whose fault it is, a party injured always is entitled to a certain minimum amount of money. That is by default. And there are various other schemes where governments have authorized collectors of a district to pay compensation to some injured person who were in cases of hit and run where it cannot be established as to which vehicle hit you. There is no scope of prosecuting the offender. In such cases, there are some schemes where the state compensates you, irrespective of whose fault it is, no fault liability.
No fault liability.
And there are various other schemes. Now, the no fault liability also is there among insurance companies, and in policies also, no fault liability. The no fault liability is to the extent if somebody dies, immediately 50,000 is to be first deposited unconditionally, and that can be withdrawn by the heirs of the deceased. If the person is injured, 25,000 rupees, and that can be withdrawn by the injured or the heirs of the injured. Then comes the main claim. The main claim is based on the age of the person injured, the education qualification of the person injured, the standing in society of the person injured, and various other factors are there whereby, and there are also tabulated forms specifying as to how much money will be allocated as a compensation to whom. Suppose somebody is just an SSC student or high school student, and he dies. He will get less compensation than a degree or diploma or degree or a master's degree or somebody who's very educated. Then again, it differentiates as to the age. If a person dies at a very old age, 60 years, and then he dies, what would be the lifespan of a person? That's the manner of computing. He or she has spent already 60 years of his life. How much more could that person live? Maximum 80. So the compensation will be for that 20 years period, that gap. And supposing young person dies, then they will compensate up to 60, 65, 70 years. Because usually that is the lifespan of a person. Standing of a society, whether he was a rich person, whether he was capable of bringing in good salary, what was his income at that point in time, whether he was employed, not employed, various factors are there. Based on these factors, the court comes to a conclusion that as to how much. Same thing is for injury also. If the hand right is damaged, if a finger is damaged, how much is to be compensated? If a left leg is damaged, how much is to be compensated? If the eye is damaged, how much is to tabulated for that? So we cannot decline. Sorry for the interruption. Uh, so we cannot decline. We cannot make a very thorough appraisal. Has to be some amount of flexibility, and that is decided by the court, taking all these factors into consideration, and the court passes an award. That award is to be executed thereafter. But in insurance companies, in the business of insurance, the aggrieved injured person or his or her heirs, filed a claim, and the parties against whom the claim is filed is the insurance company, the driver of the vehicle also. Sometimes there are multiple drivers, a driver and owner of the vehicle and other vehicles. If there is a bash up of many vehicles or many vehicles were instrumental in causing the accident. So now the insurance company will check whether your policy was valid, when was the policy taken, on what day, what time. Time is important over here, because we may take a policy, say on the 11th, today 11th of May, and the accident happens on 11th of May, but yet you will not be entitled. Sometimes you may become entitled, sometimes you may not become entitled to compensation, because time is an essence of the contract. If the contract was entered in at 5 o'clock on 11th May 2022, and the accident took place, before 5 o'clock, you don't become entitled to it, because there was no insurance.
Yes, not entitled.
There was no insurance policy.
Mm.
And suppose it is after 5 o'clock. Sometimes again you may not become entitled, because even though you have taken the policy, you may have paid the money, but it is not registered in the books. So in such an event, there is something known as a cover note, just like you have in the share bazaar rather. There is something known as a cover note. So this transition period between paying your premium and entry as a policy holder or insured, this transition period is protected by virtue of the cover note. Even by virtue of you have entered, if your name is, if just a cover note is given, you have taken insurance at 6 o'clock today evening. The office closes at 6, so they cannot make the entry because the staff may have gone. But that cover note will save you. So when you are defending your client, you should see all these factors: time, cover note, etc., etc. And you may have taken, sometimes you may have taken insurance, and sometimes somebody else also have taken insurance in respect of you and a third person. So the aggregate insurance that you have taken, say is 10 lakhs. But if the property, if the damage done is less than 10 lakhs, then that amount only will be given. You cannot insure a person. Suppose I am worth only 1 lakh rupees, and somebody has insured me for, my parents have insured me for 5 lakh, and I have insured myself for 3 lakh, and then somebody else has insured me for some. So that my aggregate insurance will be uh, about 13, 18 lakh rupees. But that will not be honored, because insurance is not a gambling. Insurance is something that you have to be merely compensated for losses incurred. So if my actual worth, net worth is only rupees 1 lakh, then the maximum I can procure is only rupees 1 lakh as compensation, irrespective of how much insurance I may have taken. See, so these are some of the things that we. Now let's look at the insurance. Uh, what happen? What do advocates do in a day-to-day for compensation when you go to the tribunal? As advocates for, if they are for the insurance company, their job is only to defend. Hardly any case comes wherein they have to prosecute. When you're for the company, you defend only. As a defense, you as playing the role of a defense advocate. What would you have done? The claim comes in, you scrutinize the claim, you read the claim, peruse the claim, and according you file your WS. Your job is mainly to file a WS, and thereafter, at the most, you have to make frame issues, and then there will be argument and written arguments or whatever, and a judgment. Yeah, of course, in between there will be interlocutory orders, etc. Sometimes for inspection or whatever, or any other thing. But mainly it is WS. The problem today is most of the advocates, senior advocates, either they don't know or they know it too well, but they are not willing to teach their juniors. The finer points of law. They don't want to share knowledge.
Yes.
There can be only two possibilities to my mind. I may be wrong, I don't know. But by and large, I see all advocates just denial. They go in denial mode. If any allegations are made that that vehicle hit me because brakes failed or because the light was wrong, red light was just changed or something, or somebody hit from back, and as a result of there was this cascading of accidents. They do not want to apply their mind. They just go on denying. This is denied. That is denied. That is denied. Every paragraph is denial. This denial form, even in the CPC also, apart from otherwise also, even if you see in a civil case, lot of advocates today, young advocates, go on simply denying anything and everything. Sometimes they create a laughing stock of themselves. The judge laughs at them. What are you denying? Do you know what you're denying?
Yes.
Apply your mind. If you go on denying everything simpliciter, as per the law of civil pleading, just a simple denial doesn't mean that issue has been negated. The denial has to be specific. Let me give you an example. Suppose in a civil suit, somebody says that somebody has put a claim against me that I owe them rupees 10,000. Just an example. I owe them rupees 10,000. So my reply shouldn't be, I don't owe you rupees 10,000. My reply should be in such a manner, it should say that I do not owe you rupees 10,000 or any other amount whatsoever. I do not owe you rupees 10,000 for the reason alleged or otherwise. So it should be specific denial. So there is no room, no scope for the person to take a counter stand. You demolish that person and seal their fate there and then. So that should be the mode of denial. Not just a denial in the air. So these are the things that we should learn. And now another thing that I have observed among advocates in their defense, they do not take the mode of, for example, estoppel, the rule of estoppel. Lot of them are, they fail to point out. Then they do not take recourse to various other. Of course, the Evidence Act is not religiously applicable to tribunals, admittedly. Nevertheless, you can lead evidence in accordance with the Evidence Act, but not religiously to be observed. So if you deviate slightly from the Evidence Act, it should be acceptable because consumer forums, family court, accident tribunal, and certain other courts, cooperative courts, etc. These are tribunals or institutions or forums where the Evidence Act is not to be religiously followed. So you can you can derive advantage of this and twist it to your benefit. Yeah. Give me 1 minute. Yeah. There are various types of insurance, and in insurance, if you in insurance, the more technical background you have, the better you can defend your client. Suppose you're on the side of where you're claiming something, you're for the claimant. If you have a good background of engineering, various types of engineering are there. You take it under the nomenclature engineering only, which usually, by and large, most advocates do not have. Most advocates are BALLB.
Yes.
Then the next most is BCom LLB. We have very few BSc LLB.
Yes.
And the least you have is BE LLB.
Yes.
BE, Bachelor in Engineering, whether it's mechanical, electrical, electronics, or whatever, or civil engineering, whatever. You have very few in medicine background and law and engineering.
Yes, exactly.
BLLB is flooded. They can do okay. They fare well. I don't mean to criticize them. They fare well when psychology is concerned, with sociology is concerned, and such things are concerned. And financial crimes, BCom LLB do well. But in this kind of accidents cases, if you have a technical background, you have a vantage position over others. I remember where police but made a detailed report and brought it. But the opponent advocate, and they were trying to rely on that report. That was for the criminal case. But the prosecution in this compensation matter tried to rely. They tried to rely on that. Because sometimes we use one document from one case to another case. We use one document which is being used in the criminal matter to establish our case in a civil matter. Sometimes it's done like this. So this person made out a big diagram and all, but the advocate was so smart. He pointed out to the honorable learned judge that this brake marks of the vehicle, which shows that the tires was scraping across the bitumen for this many meters. This is not possible because that road on which the accident took place is not a tar road, not with bitumen. It's with concrete, and therefore these marks could not have come. So this report, what was being made by the police officer, was made sitting in his chamber. He did not visit the site. As usual, they make the panchnama and take signatures of people. You come sign this. You come sign this. So these are the dangers of relying on these documents, and at the same time, this is the smartness of the advocate. We should give him credit for that. had he not had a technical background, he would not be able to have pointed out to the Honorable Learned Presiding Officer that these marks could not have come about. The marks that are sought to be shown in the diagram are a figment of imagination.
Yes.
So this is how we go. Actually, in an accident tribunal, number of people appear. Some people who are not even advocates appear, and the quantum of knowledge that they have is either at par with advocates, or I would say sometimes far superior to advocates. Advocates lose with them. There are times when a layman wins.
Yes, of course.
So it is a
Sometimes.
technical aspect of it, how you use it.
Yes.
Now there is something known as disciplinary action. Disciplinary action against the insurance companies. Insurance companies have, besides the insurance policies, they have bylaws and they have insurance act, but they are governed council, they have field, they have medical. So the body by the government to regulate all insurance companies and the various types of policies and any other disputes that may arise. So you can go in for redressal to the IRDA, or you could also go to the ombudsman. There is something as an ombudsman. But when you go to the ombudsman, you cannot engage an advocate. No doubt, initially you send a notice to an advocate. Subsequently, you're called on your own. And once an order is passed by the ombudsman, the insurance company has to honor it. Or else it is to be challenged at the High Court. So this is one of the schemes. Now there is something in-house, which a lot of people don't know. There is an in-house understanding or a rule or regulation for insurance agents. Agents and what you call that? I can't get that word. One thing is insurance agents, and another thing is 1 minute. Give me. Sometimes I'm getting old. I forget. I seem to forget some things. Insurance agents are one type of people who do insurance business, and there is also insurance brokers. Yeah, I got it. Brokers are firms that do insurance, and agents are individuals or even an institution that does insurance. Sometimes you might have a sole proprietorship, or you have something like that, or limited liability partnership and things like that. You have individuals doing insurance business. Sometimes they do it as in the individual capacity. Sometimes they do as an agent for the insurance company. When they are engaged as an agent for an insurance company, they have to follow some principles of insurance that is for practitioners, for insurance practitioners. And as you know, as per the Contract Act, if an agent does something wrong, the principal is responsible. Therefore, if these agents do something wrong while selling the policy, whether it is non-life or life, they are responsible. If they are not responsible, the company is responsible. And here is the catch. If you are a smart and shrewd advocate, you will examine the policy. Examine the handwriting of the policy. Hello?
Yes, sir. It's clear, sir.
Examine the handwriting of the policy. If the handwriting isn't that of the insured, that is one point, brown point in your favor. Why? The reason being the policy states and the insurance rules state a policy granted to anybody is to be filled up in the performer by his own handwriting. And not by anybody else, not by relatives, not not even agent. The agent also is not authorized to fill in the the blanks that are there in the performer. There are forms, and we have to fill the age, where an accident, do we have glassing, that thing, etc., etc. Lots of things are. Nothing should be by. Sorry for interruption.
Yes.
Nothing should be filled by the agent. The moment the agent fills that form, the company becomes liable because he has done something in breach of law. Because he has done something in breach of law. So this is one of the weaknesses. Second, another funny thing about insurance law is, even assuming we both are agents, and if I get to know some wrong about you that you have done and facilitated or indulged in respect of the policy, it is a very shameful thing to say. I'm saying it, but in a duty is cast upon me not to disclose your wrong. Can you imagine something like this?
Not to disclose.
Usually, a law is such that a duty is cast upon every citizen to point out any wrong.
Yes.
But in this case, a duty is cast upon your colleague in the profession not to disclose your wrong. So these are things that now, if you study the Insurance Act and if you are an agent, you get access to these special privileges. You get to know the working inside of various insurance companies, how they function, what are their policies, and such other weaknesses which you would not have otherwise got access to. So if you want to make a good advocate in the insurance sector, it is better you go for short-term training of 3 months training to various insurance companies. If you have got insurance training in 3 or 4 companies, life and non-life, thereafter you'll be a master and be able to play around with everyone.
Yeah, sir. Yes, of course.
Because there are these small insurance schemes,
Yes.
training schemes, but those training schemes are only persons who are coming in as agents are entitled to the training, not everybody. So you join the scheme, take the training, and then leave. Again, go to another insurance company, take the training, and leave. So you get exposure to various type of insurance companies. You get various exposure to various types of insurance, life and non-life. In 4 trainings, that is 1 year, you have nearly mastered the whole profession.
Yes, exactly.
If not anything. So this insurance sector is a very funny sector. You have insurance of ships, you have insurance of the hull of the ship, you have insurance of the sailors of the ship, you have insurance of the cargo of the ship. Then there is a sort of understanding in shipping industry. If a ship is listed means tilted, or there's rough seas, and uh, there's a danger of the ship sinking. Shipping companies are permitted to discharge the cargo mid-sea. Discharge the cargo meaning they can lift up the cargo from the hold and throw it into the sea in order to maintain balance of the ship. Now the loss of cargo, who will pay? That question arises for consideration. It is covered by insurance and it is justified. Had it not been thrown into the sea, the entire ship would have sunk. See, sometimes they have to, in order to balance the ship, you have to pump water into the holes, deliberately pump water into the hold, 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 to maintain the weight. Sometimes you have to pump air into another hold in order to keep it afloat. So there are various, if the ship is listing or tilting, deliberately throwing the cargo into the sea is permissible. Then when a ship sinks, and if it sinks, sometimes it is written off as a dead loss. Sometimes the salvage of the ship is a compensation that the shipping company will take away the salvage in order to honor your contract, insurance contract between the shipping company and the insurer. So these are funny things that come in the field of insurance. It is a very wide subject. Take insurance of uh, fire. Fire could have been. How does one go about investigating what was the cause of the fire? Let us presume there is a fuse, an electric fuse. In the manner in which the fuse has gone off, will be an indication as to what was the cause of the fire. If there is a blast and the fuse wire has disintegrated with fine granules formed all over the interior of the fuse cover, that will indicate that there was a short circuit. But if the fuse wire has merely melted and broken in one place, that is an indication of overload.
Yes, sir.
Same thing with chemicals, as to how there is an explosion and why there was an explosion. Supposing there is a fire in a godown, and that godown contains, besides other things, calcium carbonate. Fire brigade comes. Obviously, when the fire is there, people will call the fire brigade. Fire brigade comes, and they start usually with, if they cannot get the details, the manifest of all the material stored in, what is the contents of the material stored in that storehouse or warehouse. Usually, they start fighting the fire with water. Now, water in such a case would be very, very dangerous, because when water comes in contact with calcium carbonate, acetylene gas will be formed, which will aggravate the fire and cause an explosion. So, the more you know about technical things, the better you can conduct your case. Therefore, I advocate seeking to go into the field of insurance to somehow or the other acquire some technical knowledge and read between the lines, because insurance policies are different policies, different type of agreements, unlike the conventional agreements. Insurance policies, share market policies, and there are certain other policies which are very unusual. Because in insurance it says, in the event of this thing happening, then you will get an compensation. Normally, what does the contract act say? A contract has to be, I'll purchase this property located at this place for this price. Everything is finalized at the inception. I shall purchase this property. The description is given of the property at this price, at this place, at this time. When you will purchase, everything is given. Everything is finalized at the inception itself. But here it is in the event of. So until that event comes into existence or occurs, until that time the contract is in animation. You don't know exactly whether that event is going to occur or not, whether it will ever occur or not. Because otherwise it could become, the contract could become void or voidable. So also in this you have, in share market also, this similar type of, you can get, the concept is the same in share market also. In the event of the market, uh, price of a particular share, that much, then and then only I will purchase it. So these are insurance and share market. They are a specialized type of contract, and therefore you should minutely read the contract, read between the lines of the contract, and try to extract the essence of the contract. Because these are not conventional contracts. You will definitely get some plus point where you can, with which you can win your case. Yes, I have a lot to talk about this insurance. Would you want to talk about?
Uh, 1 6, sir.
Or should we take questions?
Sir, we'll take up on a few questions, sir. Following that, we'll just wrap up the session. Sir, the question is something like, what is Panchnama? What is Panchnama, sir?
Panchnama is a corrupted word. It's an Indian word that has come into existence and come into law books and everywhere. It is something where 5 people are supposed to be witness to a particular incident, accident or crime or whatever. A crime or accident or some incident that has taken place. 5 persons. Punch, it comes from the word 5. 5 persons are required to bear testimony, to be witness to that. Whether it is finding of arms and ammunition in the case of criminal cases, or whether it's an accident, but usually they take 3 only nowadays, and they call it Panchnama.
Okay, sir. Perfect, sir. Sir, could you please elaborate something related to policies? We were talking about policies and schemes, no, sir. Could you please give any 2 schemes which people should be so much care and they should give lot of conscious when they are going to take about some policies?
About COVID?
What about the circumstance of COVID as well, sir? The persons who are died in the COVID and how the situation will be there for them, because lot of life losses happened during this COVID.
Nobody was ever covered for COVID. COVID was never envisaged. They could not have thought that anything like COVID would have come. So nobody was insured for COVID. But there are some general policies.
Yes, sir.
In the event of death, irrespective of the kind of death and for the cause of death. Some are general policies. If a person dies, their heirs get a compensation. So under that scheme, somebody might, if they exercise their right, they may get. Because insurance, you cannot say what is, not forget about insurance. In the court, you can never say who's right and who's wrong. It will depend on how you present your case and how smart you are, how innovative you are, how you can convince the court. It depends on your skills, drafting skills and oratory skills.
Thank you, sir. Thank you so much. It was the very important point which
Tell me
we
anything else
are
I
giving,
can.
like for drafting and the advocacy. What the advocate is going to present before the honorable judge, that plays a very major role. Whatever the act, we need to be in convincing way as well. Sir, another one question is um, like they have asked about recover loss. No, sir. You have. Could you please elaborate on the recover loss, sir? We were talking about
On what law?
insurance recover loss, sir, because insurance is not going to pay us. It is going to give the loss which we have occurred. So could you please elaborate on that point of view, sir?
For example, if your vehicle costs you 10 lakh rupees,
Yes, sir.
in the worst scenario, if the vehicle goes as total scrap, suppose a vehicle has gone down a valley and completely shattered, and the structure of the vehicle, the body of the vehicle is destroyed, the paint is destroyed, windshield is destroyed, everything, including the engine also is destroyed. And the tires are burnt and the seats are burnt and nothing is left. It's a total loss. In such an event, maximum you can recover is 10 lakh, because that is the cost of the vehicle. You cannot, you could under no circumstances have insured the vehicle for more than 10 lakh. So you can recover only as much as the actual value of that item that has been destroyed. Of course, taking into consideration what you call that in chartered accountancy, what do we say? Depreciation. Yeah. In chartered accountancy, we have something known as in accountancy, we have depreciation. So 5% depreciation per year is permissible.
Yes, sir. Thank you so much, sir. So, final question, sir. Sir, it takes long time of duration to get the recover amount if accident happens. What do you think, and what about the opinion of you, sir? Do you think this particular e-based code and all other apps will help a lot in doing with the percentage of the particular motor vehicle accident, something like that, sir? Your viewpoint, sir. Just a suggestion. Do you think this online
I
based
bet
transformation will help a
with
lot, or robotics based in future will help a lot to make people get compensation so soon? Because minimum will be like 7 to 10 years. People are suffering a lot to get the compensation as well. So your point of view, sir.
with due respect, I beg to differ. The delay of the
Yes.
delay or procrastination is due to advocates themselves. By asking for adjournment every now and then, at a drop of a hat, they want an adjournment. They have so many cases that they cannot attend, and therefore they want adjournment. That is one of the reasons. Second thing is they come unprepared. They come hurriedly running into the court, breathing hard, cannot address the judge. So this is not the way to this work. This sort of work culture is going to get you nowhere. People are blaming the system. There's nothing wrong with the system. There's something wrong with your work culture.
That was a very bold answer, sir. That was like null shit. You just said that it is the advocates issue, and systems as well need to get much more updated in future so that people get the compensation as soon as possible. Because the particular client, he just called me and he was elaborating for more than 2.5 hours. It was like he was like literally he was crying, and he was I was not able to. That was very emotional when it comes to a insurance. So he was telling, even I do have a thing and I'm not able to recover. It's like very difficult situation because he was from other country, and it was very difficult to make it sure. So thank you very much for the point, sir, and I'm very grateful to you to have this particular timing, and I think so it is very busy.
May I interrupt for 1 minute?
Yes, sir. Yes,
You
sir.
were saying something about just now. What were you saying? Something about compensation.
Insurance and yes, sir, insurance. He was having insurance, and due to COVID, he was not able to recover. So it was a very big case. He was elaborating for more than 2 hours. So the pain, I could only understand the pain of the person because he was struggling. He got stuck
Yeah,
up in.
there are two kinds of compensation. One is ad interim compensation. You get it immediately,
Okay, sir.
and another compensation you will get at the end of the case. That is a award. So, if I said if the person dies, 50,000 rupees is ab initio, there and there, immediately within a day or so, you should get it. Within a day or 2 days or 3 days, they will have to deposit in the court, either the insurance company uh, or the driver of the vehicle or owner of the vehicle. So 50,000 you will get immediately. And if it is a case of accident injury, then 25,000 you will get immediately. The rest of your claim, whether it is 5 lakh, 10 lakh, 20 lakh, 1 crore, 2 crore, that you will get at the final award, when the final case has been heard and disposed of. So initially you're getting 50,000. 50,000 of course is peanuts. Nevertheless, they have made it like that. 50,000 for death.
Yes, yes, sir.
Two
Thank you.
combinations are there.
Yes, yes. Thank you so much, sir, for the adding point to it. Sir, I would like to give a formal vote of thanks. So, thank you so much because this is very important
I should
topic.
be thanking you.
It's all right, sir. So it is really very useful session, sir, because this takes more than 6 months to cover it up. But you just covered within 40 to 50 minutes. You just covered whatever I studied in my LLB honors. It is honest answer. So it was very great, and it was very elaborate, and it was very, very informative, sir. Really, you covered civil procedure, criminal procedure. How about the police station procedure goes on, and what are the disadvantage of person taking advantage of the system, as you said, advocates negligence, or it may be the negligence of the insurance company, the promise which have been broken out. So it's like vehicles, we cover transportation vehicles, we just covered, you just covered the ship based accidents and space based accident. I would like to have another important session on your as a chief guest for stock market, and I want to represent,
Sure,
you need
sure.
to represent particularly for the a topic, another topic like tribunals, tribunals, and how it is working, and who are the persons who are going to take upon, because family based courts as well as other tribunals, you need to take another day for it. You should give important for those topic as well, sir. And I will, we will just conduct another Portuguese based law as sir has recommended before. Make sure I need the schedule for it.
Yeah, it is
And
important.
yes, sir, yes,
Because a
sir.
lot of people are not aware about the Portuguese law.
Yes, we need to do it definitely for sure. And it was very informative. So it was very informative. People were not able to join, but they are in messaging me because of the climate. Here we do have a unpredictable climate weather condition. It is raining, so people were not able to connect. So I will make sure I will give this
Okay.
recorded session in YouTube. And thank you so much for your presence, sir. Thank you so much, sir. We will just end the session, sir.
Welcome.
Yes, sir. Thank you. Thank you so much, sir.
Thank you.